Hello everyone, myself Dr. Gaganpreet. I am working as Assistant Professor of Law in Rajiv Gandhi National University of Law, Punjab, Patiala. Today we will be discussing the topic of theories of punishment. The basic purpose of punishing an offender under any criminal justice system is to reprimand the offender for violating the laws. Nature of the punishment should be such that it deters the offender as well as the prospective criminals from indulging in similar acts ever again. Prevention of mischief has been regarded as the sole aim of punishment by Bentham. Infliction of punishment on the offender should have retributive, deterrent, restorative, and rehabilitative effect on the accused and the potential offender as the main objective of the punishment. Certain attributes of punishment have been universally accepted world over, such as that punishment should be generally harsh, evil, and unpleasant in nature. It must be inflicted only upon the violation of the laws or set of rules. No innocent person should ever be punished. That is, only the guilty person should be punished. Punishment should be proportionate to the nature of the offense committed. Moreover, punishment can be granted as well as inflicted only by the appropriate authority. Theories of punishment. Every criminal justice system works on the objective of punishing the violators of the law, so as to make society a safe place to live. Guilt of the accused should be determined conclusively before any punishment is granted to him. While granting the punishment, the object or motive behind it determines the type of punishment to be prescribed. Whether the motive of punishing the offender is to deter the minds of the people, or to prevent crime in society, or to make the convict pay for his act, etc., are few determinants upon which the quantum of punishment will depend. There are 5 theories of punishment that have been employed by the judges while deciding the appropriate punishment, which will both deter and reform the convict. These 5 theories of punishments are, namely, deterrent theory, preventive theory, retributive theory, reformative theory, and expiatory theory. Now we will be discussing the deterrent theory. In ancient times, different modes or forms of punishments were mainly deterrent in nature. To deter means to refrain the person from doing an act. The objective of this theory is to deter the criminal from committing the crime in future. The deterrent comes from the harshness or severity of punishment. The proponents of this theory emphasize that nature of the punishment should be such that it should create fear in the mind of the offender, as well as in the minds of the general public. It should deter them from indulging in similar acts in future. The objective behind this theory is to demonstrate it to the offender that crime can never be a profitable bargain for everyone. Locke propagated that punishment should be such that it should make crime an ill bargain to the offender. By making it an ill bargain to the offender, the world at large would learn that crime is a costly way of achieving an end. Jeremy Bentham, the propounder of this theory, based this theory on the principle of hedonism, which said that a man would be deterred from committing a crime if the punishment applied was swift, certain, and severe. Bentham went to the extent of propagating the use of capital punishment or death penalty as to derives the criminal of his power to commit similar type of crime in future. Bentham also treats the offense as a past act and use it as an opportunity to punish the offender in such a way to prevent future offenses. Deterrence is basically of two types, general and specific. Prevention of crime in the society as a whole is the basic purpose of general deterrence. Thus, the purpose of the state or authority in awarding and inflicting punishment on the wrongdoer is to set an example for the general public who has not even participated in such criminal activity. The purpose is to make the public aware and create fear regarding the consequences of indulging in such criminal acts. Specific deterrence is directed specifically towards the individual offender. The nature of the punishment should be such that it discourages or creates that much fear in the mind of the offender that he fears that very idea of committing a similar act in future. The criticism of this theory is that it proves ineffective in cases where the crime has been committed by the wrongdoer under severe mental distress. In such situations, punishing such a wrongdoer to deter him proves pointless. Next theory, preventive theory. This theory is founded upon the idea of prevention of crime. It propagates that the objective of the punishment is to deter the wrongdoer from committing the crime again in future. That may be by disabling the offender by such measures such as imprisonment, capital punishment, suspension of license, etc. This theory has the support of the utilitarian law reformers, as it has humanizing influence on the penal law. Moreover, according to them, it is the certainty of punishment as well as its severity which actually impacts the wrongdoer. The advent of prison system owes its existence to this theory of punishment. Primary objective of punishment, according to the traditional notion, is to create fear in the mind of the criminal, and the secondary object is prevention of the crime in itself. Prevention can be by way of disablement. Imprisonment is nothing but disablement by isolating the criminal from the society. The most foolproof measure of disablement is by inflicting capital punishment upon the criminal, although such punishment can be awarded only in case of heinous crimes. In less serious offences, disablement can be by way of forfeiture of office, suspension or cancellation of license, etc. In modern penology, disabling act has been provided in the form of conferment of such powers to the judicial officers to award enhanced punishment to the criminals who are habitual offenders. The ultimate objective of this theory is to restrict an offender from recurrence of crime by incapacitating that person by imposing punishments such as imprisonment, death penalty, or exile. In olden times, this form of punishment had a bearing on the nature of the crime committed by the offender. As a result, the body part involved in the commission of crime was chopped off, so that the offender is rendered incapacitated for recurrence of similar crime in future. For example, in the crime of theft, major role is played by the hands, so the punishment for such an offense involved chopping off the hands of the offender. Similarly, in case of sexual offenses committed by a male, the private parts of that offender were chopped off by applying this preventive approach of punishment. The idea is to render criminal disabled so that he cannot repeat similar offense in future. The modern penological approach disapproves of such barbaric nature of punishment. That is why such punishments do not find place in the criminal laws of civilized states. However, capital punishment has still been retained by many countries. The biggest criticism of this theory is that the nature of the punishment provided to the criminal is very harsh. This theory aims at prevention of crime. However, it is more society-centric and ignores the perspective of the offender. Moreover, this theory also ignores the basic objective of the criminal law, that is, reformation of the offender. It is a very well accepted notion now that punishment is a mechanism of social defense and solidarity necessary to protect the society from criminal-minded persons. In this background only, the institution of prison has evolved. The incarceration of the offenders actually incapacitates the criminal-minded person from committing the crime again. Thus, incarceration serves three purposes: protection of the society, incapacitating the offender without turning to barbaric mutilations, and punishing the offender by deprivation of liberty. Thus, pressurization of criminals was considered to be the best method of prevention of crime. Retributive theory. Contrary to the approach of the deterrent theory, which is considered as a means of achieving social security, retributive theory is an end in itself. The philosophy of this theory is vengeance or revenge. This theory is based on the Roman doctrine of Peona sonus tenere debet actus entron alias, which means punishment belongs to the guilty and not others. This theory propagates punishment only for voluntary acts and not for involuntary acts like acts of persons with unsoundness of mind. The basic idea of this theory is that the offender should suffer as much pain and sufferings as inflicted by him on the victim. Tooth for a tooth and an eye for an eye is the basic principle of this theory. Retribution is where the wrongdoer pays for his wrongful act, since the person affected by his act would like to avenge himself. The punishment by the state is a substitute for private vengeance. The state seems it necessary to inflict some pain on the offender in order to prevent private vengeance. Retributive theory is closely associated with the notion of expiation, which means that the guilt of the offender eliminates once he undergoes an appropriate punishment. The idea behind retributive theory is to make the offender realize that what he did was wrong and that he should not indulge in similar behavior in future. Also, the retributive punishment is neither cruel nor barbaric, but civilized, because the punishment inflicted on the offender is in proportion to the crime, which is just. Retributive theory is unbiased in nature, as it protects the interests of the offender as well as the society at large by imposing proportionate punishment to the wrongdoer for the act committed. On the other hand, reformative theory is more criminal or wrongdoer oriented, and deterrent theory is more society-centric. Criticism meted out regarding this theory is that it lacks proper guidelines or principles regarding proportionate punishment, which becomes a Herculean task for the judges to make judgment regarding punishment for crimes. Moreover, ultimate objective of punishment is not just to incarcerate the wrongdoer, rather to prevent its recurrence. Reformative theory. An eye for an eye would turn the whole world blind. This approach of Mahatma Gandhi reveals the ultimate objective of this theory. This theory is the most recent as well as the most humane in its approach. It emphasizes on individualized treatment to the offenders with the objective of reforming the offenders. This theory works with the presupposition that offenders or criminals are not inhuman, and they can be reformed if they are given proper treatment while serving their punishment, as well as the nature of punishment awarded to them, keeping in view the factors such as age, circumstances, first-time offenders, etc. Success of this theory is based on the realization of the guilt by the offender and his desire to change himself. This theory is based on the principle of hate the sin and not the sinner. This theory is different from other theories of punishment as it strives to bring about a positive change in the perspective of the criminal and to assimilate that person as a law-abiding citizen of the country. The ultimate objective is to reclaim and rescue the offender and not to subject him to torturous treatment. As part of the reformative theory, while awarding punishment, judge should be considerate about the age, character, environment, educational qualifications, as well as the circumstances in which the crime was committed by the offender, nature of the crime, objective or the intention, and other factors behind the commission of the crime. The whole idea is that before the pronouncement of the quantum of punishment, the judge should have a fair idea what were the factors which influenced the commission of crime. The advocates of this theory believe that compassionate and sympathetic treatment of the offenders can bring about a radical change amongst the wrongdoers. The ultimate objective of this theory of punishment is to rehabilitate the wrongdoers and to convert such persons into law-abiding members of the society. This theory totally denounces the idea of corporal punishments. This theory can be really effective for the first-time offenders and young offenders, but proves ineffective for hardcore criminals. Thus, every theory has its own merits, and one theory alone cannot prove to be fruitful. Therefore, in such cases, the importance of retributive theory as well as the deterrent theory cannot be ignored. Reformation can be achieved by resorting to non-custodial measures of punishment such as probation, parole, pardon, and intermediate sentence, etc. A perfect criminal justice system cannot be achieved by the application of single theory of punishment. However, a blend of these theories can result in the achievement of this goal. The last theory, expiatory theory. This theory is of peculiar characteristics, which are very well ordained in the Hindu jurisprudence. According to this theory, punishment is necessary for the purification of the offender. According to Manu, men who are guilty of crime, when condemned by the king, become pure and go to heaven in the same way as good and virtuous men go. Expiation is to some extent akin to the idea of retribution. Fry observes that punishment should be in order to adjust the suffering of the sin. Oppenheim is of the opinion that punishment is the purification not of the individual alone, but of the humanity as a whole. This theory is based on the belief that if a wrongdoer expiates or repents his wrongdoings and realizes that he has made a mistake, then he must be granted forgiveness. This theory had prevalence in ancient times and has become obsolete in the modern context. In conclusion, we can say, every criminal justice system works on the objective of punishing the violators of the law, so as to make society a safe place to live. Guilt of the accused should be determined conclusively before any punishment is granted to him. While granting the punishment, the object or motive behind it determines the type of punishment to be prescribed. Whether the motive of punishing the offender is to deter the minds of the people, or to prevent crime in society, or to make the convict pay for his act, etc., are few determinants upon which the quantum of punishment will depend. All the theories of punishment encompass their own pros and cons in practical applicability. Therefore, an ideal criminal justice system should be a culmination of different theories of punishment, taking into account the good points of each. As a criminal justice system based on any single theory of punishment would not result in a healthy and effective system. Section 53 of IPC prescribes different kinds of punishments, namely death sentence, life imprisonment, simple imprisonment or rigorous imprisonment, forfeiture of property and fine, etc., but does not mention the object of punishment. Indian Penal Code, excluding exceptions, prescribe the maximum punishment and leaves the imposition of appropriate punishment in the hands of judiciary, which makes the IPC flexible. The capital punishment that is part of the traditional deterrent theory is retained and continued in the Indian legal system. Although the court has to record reasons for awarding death sentence, that means life sentence is the rule and death sentence is an exception. Indian criminal justice system has more inclination towards reformation of the criminals, and in that direction, number of initiatives have been introduced to make the criminal justice system more effective and provide a chance and opportunity to those offenders who realizes their mistake and want to return to normal life and quit the life of a criminal. Thank you.